Welcome to our Remedies seminar. In this seminar, we're going to go over the most important subject that is never listed on the bar exam, remedies. And we're not going to cover any new ground. What we're going to do is review and go into a little bit of greater depth. This introductory video is the only new piece that you will see substantively. After this, we're going to see replays of the remedies section of torts, contracts, and real property. So there will be a total of 4 substantive videos in this seminar, including this one, and then the important part. We'll go over 6 new hypotheticals that present complicated, difficult remedies issues, and that give us a chance to reinforce and continue to work on our efforts at organizing and outlining our ideas better. Remember, clear thinking, clear organization, and detailed analysis is your ticket to success on the essays, and the same language is so commonly used on the multi-state that the same issues are presented in strikingly similar ways with strikingly similar language on both parts of the exam. So, when we consider remedies, the first thing that should come to mind are the quick laundry list: damages, restitution, and equitable relief. Obviously, there's a lot more to remedies than just those 3 big ideas, but those 3 big ideas really are the heart of remedies. So let's briefly review each of them and then go through the laundry list of the other basic remedies, and then you can proceed to review torts, contracts, property, and then 6 difficult, interesting remedies hypotheticals. With regard to damages, remember that we think of damages a little differently in torts and contracts and property, but essentially the basics remain the same. Broadly speaking, there are 2 types of damages: compensatory and punitive. Compensatory damages are available to successful plaintiffs regardless of their theory of liability. If the plaintiff can prove that he or she has been harmed financially, then the jury, or the trier of fact if it's just the judge, will be able to assess a dollar amount and pay the plaintiff that compensation in damages. But remember, punitive damages are different, and punitive damages are associated with tort theories of liability, not contracts. And keep in mind that even within torts, negligence and strict liability, 2 big theories of liability, don't come with punitive damages. Punitive damages are available only to punish and make an example out of a defendant that engages in willful, wrongful conduct. So, in fact, there is sort of a sliding scale of willfulness in torts. We begin with negligence, mere carelessness. We elevate that to recklessness, and at the point that the defendant achieves a reckless level of misconduct, punitive damages become available. And of course, for all intentional torts, punitive damages can be assessed when a plaintiff is successful. Now, compare that with contracts. Contracts damages are more complicated and subtle, not because punitive damages are in the picture. They're not. The plaintiff in a contracts action has to show fraud or a breach of the covenant of good faith and fair dealing, which is implied into all contracts, in order to establish a claim of punitive damages. So in contracts, we're much more concerned with compensatory damages, and we see that compensatory damages fall into a couple of categories: those that relate to the cover remedy, direct damages that are associated with the breach, and then consequential damages, damages that flow from the breach, are caused by the breach, but are damages other than the cover remedy, the remedy of obtaining alternate performance. In order for a plaintiff to obtain compensation for these consequential damages, those damages have to be foreseeable to the breaching party at the time the contract was entered into. And so the analysis of contracts damages often turns on foreseeability, which is interesting because we associate that much more with torts than we do with contracts. Now, damages issues arise in real property also. Typically, we're dealing either with tort theories or contract theories of liability that involve real estate. but there is a special issue of damages with regard to real property, and that's where the real property itself has been damaged. And typically, the two ways that we can compensate a successful plaintiff whose real property has been harmed physically by the defendant are either we can compensate the plaintiff in damages for the cost of repair to bring the property back into the condition that it was before the defendant engaged in misconduct. And the other way that we can compensate a successful plaintiff is for the permanent diminution in value of land. Under those circumstances, we acknowledge that the defendant can't really ever make the property whole, but we can make the plaintiff whole by paying damages to the plaintiff that are equal to the diminution in value. So that wraps up a real capsule summary of all of the law of damages. You'll get a chance to review them substantively in the following 3 videos, and then in the 6 hypotheticals that follow. So next we turn to restitution. For our purposes here, the most important distinction to make between restitution and damages is, in damages, we focus on the plaintiff, and we try to make the plaintiff whole. In restitution, our focus is on the defendant. And what we try to do with restitution is prevent the unjust enrichment of the defendant. And we see that the most common analysis that results in a restitutionary award is quasi-contract. But there are others as well. Restitution is not limited to a money award. We can also see that with regard to real estate, ejectment is the remedy for plaintiffs that have a trespasser, and an unlawful detainer is an action that a landlord has against a tenant that's wrongfully in possession. Another restitutionary remedy that is regularly apparent, regularly tested, but not discussed a great deal is replevin, which in some jurisdictions is referred to as claim and delivery. Replevin is a pretrial remedy, and it's also a legal remedy, although it looks very much like an equitable remedy. In a restitutionary remedy of replevin, or claim and delivery, the plaintiff comes to court before trial and establishes a present need to have possession of a chattel which is in dispute. And so a plaintiff may have to post a bond, but a court can issue a legal order which looks very much like an equitable order, forcing the defendant to turn over the property to the plaintiff even before the plaintiff has won a verdict. Now, suppose the defendant wins after a restitutionary award of replevin or claim and delivery has been made before trial. Well, the defendant then would be entitled, obviously, to possession of the chattel, but would also be entitled to damages for the deprivation of possession during the pendency of the litigation. And that wraps up a very quick consideration of restitution. Next, we turn our attention to equitable relief, and here, in torts, we're interested in injunctive relief, and in contracts, we're interested in specific performance. And remember that you need to have a laundry list of elements for both of these memorized. That's part of the core knowledge that you've got to bring into the exam. And the reason why you need to have these elements in mind is so that you can analyze each step of the analysis, element by element. And this is not something artificial that you just have to do for the bar exam and then forget. In litigation practice, that's the bread and butter of our work. The plaintiff has to establish each element of each theory of liability in order to be entitled to a defense. And we break it up in pieces in court. Similarly, the defense may be able to attack elements of the plaintiff's theories of liability, but the defendant may also have affirmative defenses, which require the defendant to bear the burden of proof. So, now we turn to equitable relief, and with regard to mandatory and prohibitory injunctions in torts, first the plaintiff has to show that damages aren't good enough. In other words, that the legal remedies are inadequate. Then the plaintiff has to show that a property interest is at stake, remembering that modernly we define a property interest very broadly. The court must be feasible. It must be feasible for the court to create and enforce injunctive relief. Then the court will balance hardships, and then we will consider the defendant's defenses. Any defense to equity is available, not just ones like latches or unclean hands, but the plaintiff can also revisit defenses to the underlying theory of liability. And the argument basically goes like this. Look, Your Honor, I acknowledge that I have lost with regard to the theory of liability, but my defenses there were strong enough that the plaintiff should be limited to legal remedies, not equitable ones. Sometimes it can be a winning argument, and you need to be prepared to consider it. Next, we consider specific performance, and here the elements are parallel to those in torts, but not identical. The first element remains the same. The plaintiff has to show that damages aren't good enough, that legal remedies won't do the job required to effect justice. Next, the plaintiff has to show that there was a definite and certain contract between the parties. Once again, the plaintiff has to show that it's feasible for the court to enforce an equitable judgment. Next, mutuality, the weakest and least important of the elements of specific performance. Then, defenses are considered again. So remember, in contracts, the defendant may have a defense to formation, a defense to breach, and then defenses to damages, and finally, a defense to specific enforcement. Remember also that equitable restitutionary issues are present. We've considered replevin, but that's a legal remedy. Remember that a constructive trust and an equitable lien actually serve as restitutionary remedies. They prevent the unjust enrichment of the defendant. Now, I acknowledge I've been a little bit glib in this discussion. Still, the basic ideas of constructive trust and equitable lien are important, and one of our hypotheticals will present a classic fact pattern that requires us to consider a constructive trust and an equitable lien. Next, we turn to special issues that relate to contracts. There are a couple of remedies issues that really are special and only come up in contracts. These are rescission and reformation. In rescission, the court steps in and just cancels the contract on its own, indicating the parties never had a meeting of the minds, typically a mistake that is mutual and goes to the heart of the agreement is a justification for rescission. There are others. Next, reformation is where a court will fix a contract so that it will reflect the true agreement between the parties rather than the various mistakes that are present in the contract before the court. Our hypothetical work together will give us a good chance to look at reformation also. Finally, I want to touch for a moment on fiduciary liability. Fiduciary liability can come up in torts or contracts or real property, but it's also commonly tested in wills and trusts and in professional responsibility. And it also can be tested in business associations such as corporations or LLCs or limited liability partnerships. So it's important to consider and to acknowledge that fiduciary relationships really go all the way through the bar examination. You can be called on to consider fiduciary relationships in a number of different subjects beyond torts and contracts and property. And it's important to remember that a trustee, a fiduciary, must put the interests of the person or entity to whom the fiduciary owes a duty first. And often, sadly, they don't. And the result is civil liability. So remember that the basic fiduciary duties are a duty of loyalty. A fiduciary has got to put the rights and the interests of the person or entity they owe the duty to ahead of their own. And when they don't, they're going to incur liability, and they're going to have to disgorge profits and possibly pay other damages. Also remember that fiduciaries have a duty of care. And here, we'll just go with a basic negligence analysis, but remember that a fiduciary has a prudent investor rule and a business judgment rule, and also underlying these duties, a duty to diversify. And the most common area where you will see these issues tested will be in trusts. And that goes beyond the scope of this seminar, but remember, remedies is omnipresent. You can see remedies issues anytime you see civil litigation. And that's great, because being well-versed in remedies will make you sharply prepared to answer questions about civil liability in depth and with clarity. And I can guarantee you that is worth points on any bar examination in this country.